both work settings.
Oh.
So technically, we don't need a quorum to do anything
True.
other than adopt the minutes.
True.
Yeah.
Right.
Which we can always kick to the next one. Yeah.
Thank you. Good evening, everyone. I'm Deborah Lockwood, Chair of the Washington County Planning Commission. Today is May 15th, 2024, and today's meeting of the Planning Commission is called to order. May we have the roll call, please?
Yes. Commissioner Fry. He did say he was going to join virtual, but I don't see him yet. Commissioner Kaiser.
No.
Commissioner McClendon.
Present.
Commissioner Monteblanco. And Commissioner Whips said that he was going to be absent today. Commissioner Will. He did say that he was also going to join virtually. I do see that Mike, our Commissioner Fry has joined. Commissioner Fry,
Present.
we're doing the roll call. Looks like he's present. Vice Chair Maury Bidu.
Present.
And Chair Lockwood.
Here.
And it looks like Morgan Will, or Commissioner Will, just joined as well.
Present.
And it looks like we have, I think, 7 present.
Okay. Thank you.
Mhm.
May we have the director's report?
Yes, thank you, Chair Lockwood. My name is Erin Mordell. I'm the Planning and Development Services Manager here at Washington County. Tonight's director's report is as follows. Our first item is that the board is anticipated to possibly appoint a new planning commissioner on June 4th, and this candidate will replace Stacy Milliman, who had to resign when she moved out of Washington County back in April. The appointee will serve the remainder of Ms. Milliman's 4-year term and could be eligible to serve 2 additional 4-year terms. The county's current recruitment period actually goes through today. So we've interviewed 7 eligible PC candidates. We're really happy to see such a large pool of people interested in being on the Planning Commission, and they seem really great and really qualified. So we're very happy. I think we're in really good shape to have another excellent person join your Planning Commission. So we should know more on June 4th about who will be appointed to fill that seat, which will be just in time for all of our fun this summer with our 2 big ordinances going through. Another item on June 4th, Chair Lockwood and Todd Borkowitz will be participating in an open house at 6 p.m. at the Washington Street Conference Center around county boards and commissions. So this is an open house kind of speed dating style is what they're calling it, event to learn about boards and commissions that people may be interested in joining. So if you know people who might be interested in a county board and commission but would like to learn more, that will be a good event to send them to, and Todd can send out more information about that if you're interested. We have an online open house active right now for the Council Creek Regional Trail. This is a project that I think the Planning Commission has heard about several times. It's a trail that will connect Hillsborough to Pacific University and Forest Grove through the city of Cornelius. And the online open house is specific to select the preferred design. And we expect that project to go into construction actually later this year if everything goes according to our plan. A friendly reminder that we have some schedule changes coming up this summer. I believe these are already in your Outlook invites for the meetings, but we did move because of holidays a couple of our meetings. So June 19th was moved to June 26th, July 3rd was moved to July 10th, and July 17th was moved to July 24th. We think that June 26th and July 10th will be relatively lengthy work sessions on the significant natural resources ordinance. And the July 24th meeting is expected to be the first hearing. And so those will be possibly important meetings to plan to attend in person as we get ready for that. So for tonight's PC meeting, we have 2 work sessions. We're talking about parliamentary procedure and Robert's Rules of Order with Mr. Bovet. And then we will have an update on significant natural resources. Your next meeting will be June 5th, and at this time, we don't have any pressing items for that meeting, and so staff recommend canceling unless there's something else the chair would like to discuss. And that concludes my report.
Commissioner Monteblanco.
Sorry, you said July 24th will be a meeting and it'll be a big one.
Yes, we think that will be the first hearing on the significant natural resources ordinance.
It is my calendar. I don't know what I was looking at. Awesome. Thank you.
Any other questions? Not seeing any, so thank you very much. Next item is public communication. Has anyone signed up to talk to us this evening?
No, no one has. Would anyone in the virtual audience like to communicate to the Planning Commission on any non-agenda item? If so, please raise your virtual hand. And see no one,
Okay,
you can proceed.
thank you. All right, our work sessions, and I believe Mr. Bovet is the first.
Looks like I'm up first. Thank you, Madam Chair, for the opportunity to discuss parliamentary procedure. I'll try to keep this simple and quick and as painless as possible. And I'll just walk you through a few slides to explain why we do parliamentary procedure and how it works. So these are the basic reasons, at least what I distill out for why we have parliamentary procedure. The basic gist is to have meetings that don't devolve into chaos. And we don't have people talking over each other and spending a lot of time trying to figure out what folks are trying to communicate. So we have rules of procedure to make things orderly, make sure that everybody is heard and has an opportunity to be heard, and that we're fair to everyone. And that's the basic gist of why we have parliamentary procedures. In terms of how we operate, there are many different parliamentary manuals. I brought just show and tell a few examples here. We operate off of Robert's Rules of Order. It's currently in its 12th edition. I can tell you that most local governments that I've worked with adopt Robert's Rules. It's really practical and more pragmatic for smaller bodies, local governments. Most cities, counties, special districts all use Robert's Rules. I will say, even though it's a paperback, it's gotten quite thick over time. This is the fourth edition, 1915. The original version was 1876, was even thinner than this. So they do get a little more complicated over time because they address things more comprehensively and modern life, to be honest, including virtual meetings, which if you would have asked me about virtual meetings 30 years ago, I would have said, what is that? Because that didn't exist. Of course, neither did emails. So as life gets more complicated, Robert's Rules addresses these issues. But it's not the only set of rules. There's other sets of rules. There's Mason's Manual, Demeter's Manual. Those are generally better for larger bodies. Our legislature, for example, uses Mason's Manual. So if you ever in a legislative hearing or you're watching the House of Representatives, and why didn't anybody second that motion? Or why are they doing that? It's because they use a different set of rules. And those rules work better for larger bodies. I've tried to actually use Robert's Rules for my previous client when I had 120 bosses, all elected officials. These work very clunky for big bodies, and especially if you have really smart people that understand Robert's Rules and they come up with very strange motions in large bodies, they can devolve very quickly. But Robert's Rules works really well for a body of this size, for local governments. And so that's what we've adopted. And like I say, most local governments have used Robert's Rules for as long as I can remember. Where it fits in the order, the pecking order, is literally at the bottom. So if we technically just applied Robert's Rules, we might walk into violations of things like the public meetings law, might violate our charter, might violate administrative rules. So really, it's at the bottom of the pecking order. It fills in all the gaps that aren't already covered by public meetings law, state administrative rules, our own charter, and the Constitution. So to the extent that anything is in conflict with any other statute or rule, those trump, and Robert's Rules fills all the gaps. So structurally, you can think about it that way. In terms of the basic rules, I got a couple slides for you just to go through real quickly. The chair is in charge, and the chair is charged with making sure that we're in compliance with Robert's Rules. And there are just a few things to keep aware of that Robert's Rules really does raise up and highlight. First is people need permission to speak in a meeting. And generally speaking, there are some exceptions. I'll talk about one important one here in a few minutes, but generally you get permission from the chair, just as the commissioner just did of the chair here a moment ago, and the chair recognizes the person. That way, people aren't talking over each other. Only one person talks at a time. And one question is generally considered at a time. Now, sometimes when motions get complicated, you can have questions within questions. You set aside a question and you address another sub question before you get back to the main question. We'll talk about that a little bit more, but generally only one question at a time. Robert's rules, basically, with some exceptions, requires a motion, a second, and then we go through the process that you're all quite familiar with, which I'll actually lay out right here. This is the basic process for, I would say, nearly all of the decision making that this body will engage in, with very rare exceptions. And I'm certainly here to help you with those exceptions when and if they ever do come up. And it's the basic process that you've seen over and over again. The speaker is recognized by the chair. The speaker makes a motion. The motion is seconded by someone else on the commission. The chair states the motion and acknowledges that a second has been made. So it's a live motion on the floor, and the chair calls for discussion, deliberation, and or debate, 3 Ds. And then after all that's done, chair calls for a vote. And I'm here to assist in case you want to take a roll call vote. It doesn't have to be a roll call vote, but in many cases, that's what we like to do, because we have to, under Oregon Public Meetings Law, make sure that our record is clear as to who made the motion, who seconded it, and how every individual voted. Whereas sometimes if it's just a bunch of ayes, you can't really tell that. And so we might comply with Robert's rules, but we wouldn't comply with Oregon Public Meetings Law. So often I will want a roll call vote just for clarity, particularly if it's a motion that has impact on other people outside of the commission. That's the basic process. I'd say 95% of the time, that's the entire process. That's everything you're going to deal with. But I did want to mention a few other things. But before I get there, let's talk about the role of staff and myself. We are not members of your commission, so we have no authority to make motions, obviously. We have no authority to second motions. I can raise a point of order if I feel like we're edging on not complying with Robert's rules, or if we're edging on not complying with public meetings law or our own charter or our own rules of procedure. We have our own rules of procedure as well that you're aware of. And I'll raise that. I'll just say, point of order, or I'll interject and I'll help. But I can't make a point of privilege, and I'll talk about what that means in a moment, and nor can Aaron or any of the other staff here. But I'm here to help. I'm here to help if you ever have any questions about, what's going on here? Mr. Babette, can you chime in on whether or not we're working under Robert's Rules of Order? And so I will interject points of order, but not points of privilege, which I'll talk about in a moment. So what's a point of order? A few examples I just plugged in here. Somebody makes a motion, but there's no second, but we start to engage in discussion on the motion. Well, we kind of missed a step, because if somebody makes a motion and then there's no second, the motion fails. There's no discussion to have under Robert's rules. Another example is voting on a matter without a quorum. I'm probably going to raise a point of order and say, we can't really be doing that. We got to have a quorum under Oregon Public Meetings Law. It has to be made immediately. Members can make it as well, members of the commission. You just say, point of order, Chair. Do we have a quorum? Can we be discussing this? And the chair says, oh, well, we don't have a quorum. We need to stop this discussion. And that's functionally how it works. There's no fancy dancing involved. It's just pretty basic. That doesn't need to be seconded. So points of order aren't a motion in and of themselves that need to be seconded and voted on. It's just a point of order raised. And it requires a ruling from the chair. If you want to be real technical under Robert's Rules of Order, you say point well taken or point not well taken. And that's where that verbiage comes from. Points of privilege is really to ensure that the commission and each individual members is able to participate actively. It's not as important that staff be able to actively participate, but the commission needs to be able to participate in individual members. So a point of privilege, I got a couple examples there. If a commissioner just can't hear what's going on, a point of privilege, Chair, I can't hear what's going on. Or the speaker's too quiet. Can you ask the speaker to speak up a little bit? Or I can't see the presentation. Those are all points of privilege that any member of this commission can raise at any time. And you just simply say, point of privilege, Chair. The chair recognizes you, you say what the problem is. The chair looks around, sees if there's a problem, acknowledges it, and we address it in that manner. So that's a point of privilege under Robert's rules. Other common situations that I've seen come up in front of your commission include what I mentioned, kind of alluded to before, amending the main motion. One of the things that's really common that I've seen every public body do that I've ever worked for is the friendly amendment. Technically, you won't find that in Robert's Rules of Order. It's a way of short-circuiting an elongated process under Robert's Rules of Order that if we made you go through, you would go, well, that was just really irritating. A friendly amendment is basically when you want to add something to a motion and both the person who made the motion and the person who seconded agree. Yeah, that's helping me improve the motion. That's not what I'm talking about here. When we're talking about amending the motion, it could be something that really is substantive, and it's a substantive change. And it could also be amending the motion in a way that the maker of the motion does not approve. This could be against the will of the maker of the motion or the seconder of the motion. That's essentially a motion within a motion. So if the motion was ABC and someone wants to say, no, the motion really needs to be A, B, C, D, E, F, G, or ACF is what it needs to be. Then someone says, I would like to make a motion to amend the motion and sets forth what they say. And if that's seconded, then you essentially set aside the original motion. You deal with the proposed amendment, however it works out, and then you get back to the main motion. And so that's the mechanics for how we address that. It doesn't come up very often in front of this commission, but I will tell you it comes up fairly regularly in city councils, sometimes in boards of commissioners as well. And I just thought I'd mention that. Another thing that often comes up, especially when you have long meetings, or shall I say, difficult, challenging motions and topics that have raised people's passion at times, is the so-called calling the question. Call the question, Chair. This is not a debatable motion. This is essentially a mechanism to stop discussion, debate, deliberation, and force a vote to happen. Robert's Rules of Order allows that, but in order to protect the minority, it takes 2/3 vote to stop discussion, cut off debate. That also protects the majority by ensuring that it's not just one or two people that are doing this. So we've got a clear supermajority of the commission that essentially, we're done talking. We just want to vote. And there's a mechanism for doing that. But again, it does require a supermajority. And then finally, I'll just say, I'm here to help. If you have any questions, if you get into a sticky wicket, you can always pause and say, Mr. Bovett, can we get your assistance? That's for the chair. And anybody else can call a point of order or call a point of privilege, as the case may be. So I think that's pretty much my quick 10-minute summary of Robert's Rules of Order, the basics in a nutshell for your commission. And I'm happy to answer any questions or yammer on endlessly, but probably don't want to hear that. So.
Thank you very much. Are there questions for Mr. Bovett? Commissioner Will. You might be muted.
Thank you, Chair Lockwood. Mr. Bovett, will you please go back to slide 10? I wanted to ask a clarifying question about the call to question you described. Yes. I've been in lots of meetings where somebody just says the word question, and then the question's been called for and they move to like a vote. So based on your description you just gave, it sounded to me like call to question that there's a vote to whether to end debate. So there should be a second vote if that's successful on the actual motion. So is when somebody calls the question, does that result in 2 votes?
Potentially. I have seen what you described, Commissioner, but I've seen it play out this way. and a large body that I used to represent, call the question. And then what you hear is essentially a voice vote by default where everybody says, yes, we're done. And it's like massive. And it's clear to the chair that 2/3 of the people that have voting privileges are done. And so they short circuit it that way. But functionally, that's doing all of this, just not technically correct. In a small body like this, I'm more than likely going to interject if someone says call the question and the chair just calls for a vote without taking a formal vote to see if 2/3 of your commission agrees that we should stop talking about it. So with a smaller body, it's easier to kind of control and make sure we're in strict compliance with Robert's rules, and that's what I'm here for.
So for the current chair and for any future chair, it would be good to pause when they hear the call, the question, and kind of determine whether we need a vote to end debate or not, or whether like 4 out of 6 people are shaking their heads going, yeah, let's end the vote.
Yes.
And let's go to vote. You know.
Yes. My default is going to be if it's not clear that 2/3 of the members of the commission are just done with the debate, I'm going to want a roll call vote to see whether we should call the question.
Yeah. Okay.
And then if that passes, then you immediately go to a vote on the motion.
So we as commissioners should pay attention at that moment to what are we voting on? Are we voting to end debate? Or are we voting on the original motion? And so we don't vote incorrectly.
Exactly. And good practice is to restate, to have the chair, or the chair can turn to me and have somebody restate the motion so people know what they're voting on for clarity.
Yeah. My second question was, I think at the top of this slide, amending the main motion. And you mentioned there is a process to do a friendly amendment, which short circuits the bigger process. So
I would say it's an informal process. You won't find that in Robert's rules.
Right. And we've taken advantage of that friendly amendment process to get the what you said was the person who made the motion and the person who seconded the motion to agree to your amendment. But you're saying that this is a way to force through your proposed amendment first and then go back to the original amendment if your change fails? Is that what happens?
Yes, there is a formal process to do that when it's functionally against the will of the original motion maker. But again, that requires a majority of the commission to agree to amend the motion on the floor.
Yeah. So like you said, our commission's a small body. It's usually pretty manageable. Have you ever heard of a situation where you got a body of, let's say, 6 people and person 1 makes an amendment, person 2 seconds it, and then during the discussion, person 3, moves to amend it, and person 4 seconds it, and then person 5 wants to amend that, and then person 6 seconds it, and just goes in a vicious circle and constantly amending.
It is theoretically possible, but what I've seen as a practical matter is the first amendment gets withdrawn voluntarily, and then a second motion to amend is made, and you still have the primary motion hanging. But I've only seen anything like that happen a handful of times. I will also admit to you that I have worked for people who are quite experts in Robert's Rules of Order and come up with very interesting things. I am not encouraging this commission to do that. There are much easier ways to handle it than what you described.
Yeah, that makes sense. So as a congenial body, if you don't like the motion, sometimes it's okay just to let it get to a vote rather than constantly trying to amend it to the way you wanted it to be.
Precisely. Very well stated.
Okay, I appreciate that clarification. Since I've never known you can do this kind of more aggressive form, we've always done the friendly one. It's just nice to know what the rules really are, and we can use them as appropriate. That's all, Chair. Thank you.
Any other questions? Not seeing any.
People have heard enough about parliamentary procedure.
Right. It was really helpful. Very nicely done. Thank you very much. I do have one question of staff. Would you send this PowerPoint to the commission members?
Yeah, we do post the PowerPoints on the website, but we can also send them directly.
Our next item is our update on the significant natural resources.
Oh.
Good evening, Chair Lockwood and Commissioners. I'm Michelle Miller, Senior Planner here and in the planning section of Planning and Development Services. I'm here tonight to share background and history on the county's Goal 5 program as we help prepare you for the ordinances we'll be filing next month on the significant natural resources. I also want to take a moment to introduce Kathy Corliss with MIG APG. She's our primary consultant on the project. She's with us virtually here tonight, and you can see her at the bottom corner of the screen. We'll talk a little bit more about her experiences and role later on in the presentation. She's here tonight so that you can get to know her a bit and that she can get to know you as we begin our journey on adopting our ordinance. So the focus of tonight's presentation is to familiarize this commission with a background on the county's statewide planning Goal 5 program. Some of you have been on this journey with us, so this may be a bit of a refresher for you. And for the newer members, this topic can get very complicated and dense quickly. So we felt it important to go over some of the basics about the county's current Goal 5 program in chunks and why we need to make changes to our natural resource regulations. Our team has been busy over a year at work on this project, and we're now at the stage of finalizing the draft ordinances that will propose the changes to our Goal 5 program. And it touches many elements of the county's comprehensive plan. Our projects and the changes proposed are limited to the urban unincorporated areas of Washington County and will include updates to the Goal 5 inventory, policies, and code requirements. So here are the topics we'll be talking about tonight. First, we're going to look back with a brief overview and background on statewide planning Goal 5 and the implementing rules found in Chapter 660, Division 23 of the Oregon Administrative Rules. You may hear me shorten the OAR citation by just saying Division 23 as I move through the presentation without saying the general Chapter 660. Those are where the Oregon rules are administered by the Land Conservation and Development chapter are located. Then we're going to talk about our Goal 5 program and how it works with Metro's Urban Growth Management Functional Plan, Title 13, that's called Nature in the Neighborhoods. I'm going to speak to the legal challenges to our regulations that have caused us to move with some degree of haste to make these changes after we've received some board direction on this approach. And finally, I'll introduce the Focus Look project tonight, the county's limited Goal 5 program update with more to come on our upcoming work sessions. So since the 1970s, the foundation of the statewide land use planning program in Oregon has been those 19 state-wide planning goals. Statewide planning Goal 5 requires local governments to identify and protect significant natural resource areas. It also addresses things like scenic and historic areas, but our focus is going to be on natural resources with this update. The procedures and requirements for complying with Goal 5 are in the Oregon Administrative Rules. The county adopted Goal 5 rules following an earlier version of the OARs that was acknowledged by the state in the 1980s. And these rules did not include the requirements to have clear and objective standards, which made a difference when the state law changed in 2017. And that expanded the requirement for land use regulations to be clear and objective to apply to all housing. So statewide planning Goal 5 is one of the 19 land use planning goals at the state level. It's a broad planning goal covering more than a dozen different types of resources ranging from wildlife habitat, historic places, and even gravel mines. To protect and plan for them, local governments are asked to create a number of inventories of resources that they consider significant. and go through a Goal 5 process and decide whether to protect the resource and what level of protection is required. And each jurisdiction could come up with a different decision for how to protect the resource. So the Goal 5 process is laid out in the Oregon Administrative Rules Division 23. This graphic is very similar to the county's original Goal 5 process. It shows the 3 main steps and our general timeline for accomplishing the Goal 5 process, beginning with the inventory step where the natural resources are identified. After the inventory is compiled and mapped, the ESEE analysis or the show your work phase can begin. At this step, the major type of land uses that could conflict with the natural resources, you do some analysis called the ESEE, which stands for Economic, Social, Environmental, and Energy, and it considers the positive and negative impacts of allowing, limiting, or prohibiting those conflicting land uses within the significant natural resource area through the various lenses and perspectives of the ESEE categories. And then take that analysis where you've looked at the conflicting uses and develop your Goal 5 program, which are the policies and regulations that stem from the analysis that's been done. So the elements of the county's Goal 5 program are found in many of our comprehensive plan documents, and you'll be seeing changes to all of these elements as we move forward through the ordinance process. The first one being the resource document, volume 1 of the county comprehensive plan. And that contains the original Goal 5 program background and references and reference maps, along with the ESEE analysis that was done in the 1980s. The comprehensive framework plan for the urban area, called the CFP, and the rural natural resource plan contain policies. Policy 10 is for the urban area, and it includes the policy to protect and enhance significant natural habitat. And then there's some strategies included within that policy. The community plans contain the maps and the design elements identifying and describing the community's outcomes for the sites with significant natural areas when, significant natural resources when development occurs. And then finally, we have the Community Development Code, mainly Section 422, which is our significant natural resource chapter. And those are the development review standards for the sites that have mapped significant natural resources. So each of the 11 community plans contain a significant natural resources inventory maps for the urban area. This is an example of an original community significant natural resource map showing those resources for the Bethany area, with the blue identifying the water-related resources and the green areas are what's called the wildlife habitat areas. These maps were created without computer GIS capabilities, and they've remained relatively unchanged since the 1980s. The community plans also contain design elements, some very specific, that call out local community natural resources and the desired protection measures when development occurs. And so you will see changes to the design elements through the ordinance process as well. So turning to the standards in the Community Development Code, Section 422, we have significant natural resources terms to describe the categories that were mapped in the county's original process: water areas and wetlands, water areas and wetlands and fish and wildlife habitat, so those areas that might be near the water areas, and wildlife habitat, kind of a general category of sensitive habitats, usually forested areas that are nearby water areas and wetlands, but a little further away. So here are the categories that we have listed in Section 422 for the significant natural resources. The water areas and wetlands are what we call kind of strictly limited. There's no alteration to the riparian corridor or within the water area and wetland, but there are certain allowances, including an enhancement of a degraded riparian corridor. And then there's requirements that you have to describe how you're enhancing the requirements. And so you can see there's a lot of subjectivity in those requirements that we need to address. The other category, wildlife habitat, and water areas and wetlands and fish and wildlife habitat include another standard where you have to make a finding that the proposed use in a significant natural resource area will not seriously interfere with the preservation of the natural resource or how the interference can be mitigated. So there's a couple of terms in there that don't really give us a good guidance or are not very clear and objective of what does seriously interfere mean? And then how can the developer mitigate for any of those impacts that are seriously interfering with the habitat? So one big change to the Oregon Administrative Rules Division 23 was that it set up a rule to allow Metro to develop minimum requirements for regional resources versus having local jurisdictions comply separately with Goal 5. To comply, Metro mapped the natural resources at a regional level, which I'll speak to on the next slide, and they using that inventory as the basis for compliance by providing a set of options for local jurisdiction. It's called Title 13, Nature in the Neighborhood, and the Portland regional jurisdictions may comply with these standards rather than comply with the standards found in Division 23 OARs. Included in Title 13 are policies for local jurisdictions to protect water quality and riparian habitat and to encourage habitat-friendly development practices. To comply, the county developed the Tualatin Basin specific program and applying Metro's inventory for riparian habitat and amended our comprehensive plan to implement that program in 2006, excuse me, which included some CDC changes. It basically relies on Clean Water Services to review the water-related resources and encourage habitat-friendly development practices for fish and wildlife habitat. So here's the example of that same Bethany area on the earlier slide with the Metro regionally significant inventory map overlay. This mapping was completed in the early 2000s, and it included categories of riparian habitat, those blue areas, and areas that might be adjacent to the creek beds, and the upland habitat areas, which are mapped in the green and showing those areas a little bit further away from the streams. Another important distinction from the county's maps is that these areas were mapped using GIS mapping and had classifications of the quality of the habitat. And for the purposes of the regulations under Title 13, the county is required to protect those riparian habitat areas shown here in blue. So here's a graphic depiction of the different habitat types. And habitat is generally the place where a plant or animal species naturally lives and grows, providing for food, shelter, and reproductive needs. The riparian habitat down in the center there are the rivers, streams, the wetlands, maybe some undeveloped floodplains. It includes a limited forest canopy of those adjacent areas or on the creek beds. And they provide important habitat for fish and wildlife as well as other water quality functions. The upland habitat is like what the name says. It's upland from the riparian habitat, and it's the vegetated areas beyond that habitat, including larger forested patches that provide habitat for wildlife. I touched on this at the beginning of the presentation. The state law changed in 2017 through Senate Bill 1051. It required that all housing is needed housing, so you must only apply clear and objective standards to residential development. And it applies to all land, not just buildable land. Further changes in 2023 clarified that the clear and objective requirement applied only within the urban growth boundary until a later date when it will be expanded and applied to some more areas of rural lands. Examples of clear and objective standards could include things like a fixed numerical standard, non-discretionary requirements where you can say yes or no, or the reviewer could agree with or say that the applicant has met the standard, or performance standards that describe a desired outcome. So the Crestline subdivision in 2018 and 2019 was an early test case for the clear and objective requirement and their effect on significant natural resource regulations at the county. It was a proposed subdivision on a site with county map significant natural resources in the Metzger area. The applicant preserved the wetland and riparian areas as required by Clean Water Services requirements and county regulations, and proposed a preservation of a portion of the wildlife habitat area that was mapped on the site. The county hearing officer determined that certain standards that we talked about earlier in section 422 were unenforceable because they weren't clear and objective. And the land use were later appealed to LUBA. And LUBA and the Court of Appeals agreed with our hearings officer that our standards were unenforceable because they were not clear and objective. So during this time as well, there were some in the community that have felt that the county didn't go far enough to protect natural resources and that the significant natural resource standards may be inconsistently applied. To address this, the board authorized a significant natural resource assessment and report, which provides a much lengthier history than what I talked about tonight, and some recommendations and alternatives for moving forward to get clear and objective standards. And there are some board adopted recommendations included in that. And the board directed work on an ordinance to make our standards clear and objective. And so I just brought this down here. You can see it's a pretty thick book. It has a lot of information that you might be able to reference as you're looking through your ordinance. And you can see if you have questions about how we got here outlined up until 2020. So, that's available online as well. In the spring of 2020, while we're working on completing the significant natural resource assessment report, the Land Conservation and Development Commission found the county out of compliance with Goal 5 because of those 3 subjective standards that were unenforceable. So they said we didn't have a Goal 5 program in place because we didn't have rules in place to follow to protect our natural resources. They issued an enforcement order directing us to amend our regulations to be clear and objective and gave a deadline of October of that same year. They also put in place a stay on development that might impact county mapped wildlife habitat. And it was in place until we made those changes to our community development code. So we quickly did that in 2020. We adopted Ordinance 869 and some habitat assessment guidelines to address the enforcement order. The objective of the ordinance was to address the standards that were not clear and objective and make some minor changes that would aid in the development review process. For water-related resources, it meant retaining the same limitations on what was allowed in these areas while making the standards clear and objective. And they also needs to be compliant with Title 13. For the wildlife habitat areas, it meant retaining a certain portion of the wildlife habitat areas to be preserved as the mitigation amount and allowed the remainder of the site to be developed. Habitat assessment guidelines were adopted later through R&O process that gave us details and guidance on the process and requirements for sites with wildlife habitat. So when the ordinance was adopted, the enforcement order was lifted, and but the 869 was appealed to LUBA in 2021. So LUBA issued their decision in the fall of 2021 and remanded the ordinance back to the county. The habitat assessment guidelines were also remanded by a separate LUBA order that followed. The main takeaway in that decision was that the county needed to follow the most current state Oregon administrative rules under Division 23 when making any changes to our natural resource regulations. So that means that rules and standards that are referenced also must be clear and objective. And the LUBA also found that the county needs to make findings based on the record that the statewide planning goals are being balanced with the natural resources goal, especially goal 10, housing, balanced housing with protecting natural resources. And the habitat assessment guidelines needed to have more public review and comment, and they needed to be available at the same time as the ordinance. So the Board of County Commissioners, after the remand, they approved a limited Goal 5 program update, which included updating the county's wildlife habitat area for the urban unincorporated areas, starting with the metro upland wildlife habitat and county wildlife habitat mapping. They agreed to an 18-month process to address the remand, including updating our inventory, developing regulations following the Goal 5 process under Division 23. So we were lucky, we set out for an RFP and we were lucky enough to select a very experienced team that includes Kathy Corliss from MIG APG. She has very many years of experience in the Portland metro area, helping jurisdictions like ours comply with Goal 5. She's listening here tonight. I'm gonna say hi, and you'll be seeing a lot more of her through this process as she helps us navigate the code changes that we'll be bringing before you. So after ordinance number 869A was remanded by LUBA, a petition to LCDC was again filed, was again filed, and with them by the same petitioners. That petition argued kind of the same things, that where regulations were not clear and objective, and so we were out of compliance with Goal 5, because when it was remanded, we couldn't put in place the rules that we had adopted with 869. It reverted to our original rules. And an enforcement order was issued back in May of 2023. And we need to amend our regulations by the end of October 1st, 2024 to address that clear and objective requirement. And there's also a stay currently on development that might be affected by wildlife habitat until new regulations are put in place. So to address the issues through the Land Use Board of Appeals and our Goal 5 program, we started projects we're calling a focused look at fish and wildlife habitat. It's a limited Goal 5 program update that we're starting with existing inventories with the focus on wildlife habitat. So as this slide shows, the project scope of work generally follows the steps in the Goal 5 process. Working with our consultant team, we're going through the Goal 5 process for the updates to the regulations that go beyond the metro requirements. So it includes some of the things that you can see here. There'll be there was a lot of GIS analysis that will culminate in a natural resource inventory report. There's a ESEE report that does the conflicting use analysis that helps guide our Goal 5 program decision with comprehensive plan policies, including changes to the policy 10 and our community plans. And we're making sure the standards are clear and objective in our community development code that we're proposing. So this project is a limited update because it's intended to build on existing inventories and available maps. And the inventory update process will build on the data, including the map sites identified on the county's current and metro inventories within the urban unincorporated areas. And it's going to be generally consistent with the current Goal 5 decisions and the policy direction already established. So here's the project schedule broken down by the various tasks within the Goal 5 process. And we've spent a lot of time on the inventory process and kind of talked about that throughout the past few months, and we'll share more about that at the next meeting. And then we're nearing that last item there, the public hearings this summer with the board adopting the new regulations within our fall timeline. So we're busy working on getting ready to file the ordinances for this project by mid-June. There'll be another planning commission meeting, a work session where we'll talk more about the Focus Look project itself, some of the concepts, the community outreach that we've done and what we've heard from the community. We have a technical advisory committee as well. Then we'll have another work session in July to give an overview of the content that's in the proposed ordinance and kind of give you a preview of the code language. And then July 24th through September 4th are some of the hearings dates. Well, you'll take testimony and make a recommendation to the to the board of county commissioners. So with that whirlwind tour of where we've been, we'll be happy to answer any questions that you might have.
Thank you very much for that presentation. Commissioners, I see I saw a hand up in there. Commissioner Will?
Yeah, I don't have a technical question. I just want to you mentioned a lot during the presentation about the concept of clear and objective standards. Can you just give us a brief synopsis, a couple sentences about why everybody's so concerned about clear and objective standards? And so when we're reviewing what we see, we can help determine whether we met that goal?
The clear and objective standard requirement came about through the SB 1051, which said that all housing is needed housing, and those standards for residential development needed to be clear and objective. And it's really kind of a tricky term of what is clear and objective. Usually it is a numerical number or something that you can really measure. Size of an area, a set standard that you can say, yes, that's happening, or no, it's not happening. And it gets a little tricky when you're talking about natural resources, because those are kind of very qualitative assessment of what is a quality habitat and things like that. So those kind of things are more subjective, where different people might have a different view. People might not have the same view of what that means. And it's really hard to set up standards to address that in a clear and objective manner. And if we do not have clear and objective standards, then those standards are considered unenforceable, which for Goal 5, in some cases, like what the LCDC found, was that then we would be out of compliance with the Goal 5 itself, or that program. So we couldn't enforce standards that we wanted to through the development process if they were not clear and objective. And then by that measure, we wouldn't be complying with Goal 5.
If I can just add on a little bit to that, I think too, maybe Commissioner Will, you're wondering why are those in there in the first place? And they're actually in state law in a couple of different places. So Division 23 of Chapter 660 also says that natural resource regulations need to be clear and objective. And so it's in a couple of places. I think the idea is that that way you would be treating all development applications in the same way. You're applying some non-subjective standards the same way to all developments. And so the outcomes could be more predictable. Whereas if it's a standard like you must mitigate, or you can't have an effect that's too much of an effect, that's leaves a lot of judgment to the planner, or to, in some cases, a decision-making body. What does that mean? And it might be applied completely differently on a couple different projects. So I think the idea is to have consistency in application.
Okay, thank you. So it's a fairness issue. We're helping make the process more fair to represent the applicant's interest and the county's interest and the public's interest.
I believe so, yeah. And it's more predictable also for the community. So I think the idea is kind of more all around, you know, what the requirements are and how they can be achieved, and the process should go more smoothly.
Okay, thank you for that response. Thank you, Chair Lockwood.
Commissioner Kaiser.
I had a couple of questions on mapping. So I saw the overlay with Metro map. Can you remind me when the Metro map was done? I think I remember going through the Goal 5 process back in, I don't know, it was a while ago, right? I mean, it's been a while, right?
Right, they did their mapping in the early 2000s.
So is that the most current mapping we're using, or are we taking that mapping and then developing more off of that?
We're using the county's maps and Metro's maps kind of as a baseline and a starting point. For the urban area and looking at the aerials, as well as a couple of different layers that have more recent information about where natural resources could be located, but we're not adding to the maps different sites for that aren't on either the Metro map or the county map. If that makes sense. So we're kind of using some supplemental maps as tools to help evaluate the Metro mapping and the county mapping.
I'm just going to follow up question. Chair, am I okay to go ahead and ask?
You have another question, is that right?
Yeah. Yes.
Okay, go ahead.
So using that, if I remember correctly, when we were going through that Goal 5 process, there were certain jurisdictions that did almost their entire mapping via aerial and GIS mapping, and then there were certain places like the city of Hillsborough that actually ground truth theirs, and it created a different set of maps that were in conflict with one another. And I know there were some other cities that did that as well. Not because I want to see not because I want to see somebody have to analyze a bunch more maps, but I don't know that the Metro map is necessarily considered the authoritative map. So why was that map necessarily chosen? Because it's just the most common one used, or because it's considered the best one to be used?
So remember when I was talking about Title 13 and the riparian habitat areas, we're required to comply with those standards for riparian habitat as mapped by Metro. And Metro allows you we can use it just as a identifier. It's not precise or completely accurate, right? It's aerials at a 30,000 foot level. When development when development comes in, they're required to delineate those boundaries for clean water services and kind of pinpoint where the vegetated corridor is and where the areas of added protection are put in place. So the riparian area changes over time. You're right about that. And we can't continually be updating. We don't know when a development's coming in. So one of the requirements will be that development needs to tell us where that boundary is on their site through the process of clean water services requirements.
So they'll be required during one of the development stages to provide mapping that shows that. I assume the county and/or CWS will take a look at that and verify it, and then they'll both agree to what it is, essentially, correct?
That's correct.
Okay, thank you.
Commissioner McClendon.
Yeah, I'm just wondering if any other counties have taken a swing at enacting clear and objective standards. And if so, have they been challenged? Have they been upheld, et cetera? I'm just wondering if we're starting from scratch, or if we have some kind of model to work off that's been upheld in other counties.
Well, we were kind of an early adopter of Goal 5 requirements, and we're also kind of early through this process of when the state law changed. We have unique circumstance of urban and a lot of urban areas that are unincorporated. That's kind of unique in the state of Oregon to have a lot of urban unincorporated areas at a higher density. So there's really not a clear match of protection measures. Also, a lot of jurisdictions have regulations for protecting trees that aren't significant natural resources and with limited requirements for our category called wildlife habitat. But that would be something, maybe a good question for Kathy's looked at has a lot of experience working in other jurisdictions. She might have have some additional comment on that.
And if I could just clarify, when you say other jurisdictions have tree codes, you mean cities. Others counties are a different thing. And so we're unusual for a county, and we are, unfortunately, due to legal action, kind of the first to have to do a lot of this work.
Thank you.
Well, if I might jump in then.
So, yeah, Ms. Corliss, do you want to
Name for the record?
comment? Yes.
Yes, hi, I'm Catherine Corliss with ADJ, and thank you for having me here this evening. It's a good question. So we have worked with a number of cities to update their natural resources regulations to be clear and objective, as well as other regulations in their codes. It is continuing to be a challenge with natural resources, as Michelle mentioned earlier. I've not worked with a county that's exactly situated as Washington County is. We're working with counties that are outside the metro region. So having Title 13 intersecting with Goal 5 for these resources adds an extra layer of complexity that, and then again, also because Washington County has urban and I won't say rural, but like even within the urban growth boundary, a mix of densities, it's created a really interesting circumstance. And I would say one that's fairly unique. Thank you.
Thanks.
Commissioner Kaiser.
I just was going to ask, and I might have missed this, but do we have any update on progress with the Transitional Advisory Committee? Any information coming out of that? Might be coming at a later meeting, and I think we have a representative on there, right? Is that Commissioner Will?
And yeah, I've been attending also.
Oh, okay. And I don't know. Is there updates coming from that, like at the next meeting? We don't need to go into it if it's coming later.
Yeah, I think the next meeting, we were going to talk about the community outreach and the input that we've received from different places. And that's where we thought we would talk about the technical advisory committee. And yeah, 2 planning commissioners were appointed to that. So Chair Lockwood and Commissioner Will. And it's a pretty broad range of folks. We did send a response to a question about who we've talked to on this project.
Yes.
Yeah. So that one lays out all the membership of the TAC. There have been 4 meetings on that, and we can talk more at the next meeting about what we went through with them and the kind of input we received.
Excellent. Thank you.
Commissioner Monte Blanco.
I have a couple questions on which I'm going to blame being new for the first year. I feel like I had that right. So I appreciate the questions around the clear and objective standards. And so as I wrap my head around this, is it fair to say that it's something that you want us to be keeping in mind as we are reviewing the ordinance, that you want us to think through, like, is this clear and objective?
Well, that's our hope is that we cover that, and with the help of our attorney to our counsel to make sure that you're receiving clear and objective standards. But it's helpful to have people that aren't that can look at it with fresh eyes and say, oh yes, this I don't understand this, or this doesn't make sense to me, and that lens will be really helpful as we're looking through.
I assume you're going to give us a beautiful product.
Okay. Well, and that is one of the things we actually, when last time we met with county council on this, he said, well, remember, it's not only the objective part, it's the clear part. Is it clear? Does it make sense? And so that's where sometimes if we're so embedded in it that we've been reading it over and over, of course it's clear to us, but it may not be clear to others. So definitely that lens will be really important for us.
That's a question.
Please do.
So you mentioned Senate Bill 1051, all housing is needed housing. I'm going to use like a hyperbolic example. Was that about making sure that like no one gets special treatment based on like the need, like as an example, like an affordable housing development, like can't just build in a wetland just because you need affordable housing? Is that, I'm trying to understand the intent of that. I just haven't read it.
Do you have some
So,
input on that or?
Again, I'm using
Yeah,
hyperbolic
Max.
examples.
Yeah.
yeah, and I don't know that we're situated to best answer that. Senate Bill 1051 actually derived from another bill, House Bill 2007, that same year. And its components were added. So if you actually looked at the history of House Bill 2007, I would refer to the staff measure summary and the testimony of the proponents. I'm loath to characterize it, but basically the development community, if I could summarize it, and I'll probably get it wrong, the development community wanted clear and objective standards in order to increase the potential of developing more housing. And so there wouldn't be subjective standards applied by various cities and counties such that they presented what at least the proponents viewed as unfair barriers to the development of housing during a massive housing shortage. So, but that's my characterization. And that might be way too short, but that's basically the way I would characterize it, having worked in the Capitol building at the time when this was happening.
And the needed housing, prior to that, the definition of needed housing was very limited. And so it didn't apply to counties. It applied to cities that did a housing needs analysis. And it was just the housing that they found that they needed. And so it was kind of limited in applicability, and this change opened up that applicability to all housing. It's like all housing, we need all housing. It's not just this kind of narrow subset that was defined.
Thank you. There was a mention, I think 2 or 3 meetings ago, about bringing some groups in with perspectives around natural resources and like different perspectives. Is that something that's still planned before we take a vote?
Well, we've been meeting with different groups through the process recently. Since we had our meeting in March, I believe we met with you. We've met with ODF and W, and we have meetings planned with THPRD coming up. We're meeting with other cities, but that is pretty much the extent of kind of special meetings. Our technical advisory committee has membership of a lot of varied opinions, including environmental advocacy groups as well. Ongoing, we met with the Committee for Community Engagement and their SNR Significant Natural Resource Subcommittee. We met with them a few times through the course of this project.
Thank you.
So if I could summarize, I think staff's intention is to share with you what we've heard from all the various interests that we've involved, and we think we've done a pretty comprehensive job of that, and of course through our technical advisory committee as well. Through the hearings process, you'll likely hear a fairly large amount of public testimony from people representing different viewpoints as well.
Any other questions, commissioners? I guess I wanted to just clarify that about the map. Will this project end with a map that is our map? Yes, okay. And then presumably that will have a long life, just like our previous map had a long life. Yeah. Do you have a comment on that?
Well, it's hard to contemplate doing an update to the map, but we have thought of ways to make some amendments to the map potentially, and embedded in the in the proposed language will be ways for people to make map corrections if they can produce evidence of such.
So you mean it'll be in the code?
Mhm.
Okay.
So clarification, so the maps will be like they are right now adopted into the community plans. So that's where we have all of the land use district maps and the significant natural resource maps and some other transportation maps. So they will live in the community plans. And we're looking at over time through development review, through the processes we have, that there may be changes to those maps. And periodically then we might update it based on the changes that happen over time. We're still talking about, you know, how often might that be, but that's kind of how they would get changed, I think, over time is through those map corrections.
Okay. And as we, as a commission, review the code changes, will we see maps? Okay. I
Yeah,
have
so
one other
for the
question.
community
Yeah.
plans, there will be text and then a whole lot of maps
Okay.
that you will see.
All right.
So yeah, you'll see it for all the
All right.
areas.
And then the natural resource report will include some maps as well, and that's the inventory, and it'll be a little bit different maps.
So on slide 12, you had the map that showed, I think it was Metro's map, and I had a question about that. Oh, yes, okay. So the blue doesn't mean water, right? Or what does, it does mean there's bodies of water going through, or,
It could be creeks or streams or where there's soils that hydric soils
okay.
as well.
And so if you go to that next slide. So the riparian is that little bit of water plus the area surrounding that is water dependent.
Yes.
So it has vegetation. Sometimes it might have water when you
Right,
have
seasonal,
more, yeah.
or, yeah, right.
But so it's that whole area. It doesn't mean that that's the floodplain, or it doesn't mean that that's the water area all the time. It's that's the water that is kind of the area that's kind of water dependent.
So does that mean that the map, basically all that area is protected area?
Well, it's kind of like that high 30,000 foot level.
Right.
When in some cases, parts of that maybe haven't ever developed. That might be someone's backyard. They have a little wet area there. So it's not necessarily protected at that point. It's kind of triggered when someone would come in for a development application, and it could be delineated or through the Clean Water Services process of where exactly is that riparian habitat area, and that accuracy would be determined at that time. And they use a series of maps to help figure out where the water areas are actually located.
It looks like there's a lot of development already, but possibly depending on that.
Sometimes those areas are put in a tract, a separate tract that is owned by an HO homeowners association, owned by Tualatin Hills Park and Rec Department. There's areas that are owned by Clean Water Services. So a lot of different mix of who is commonly owns those tract areas that are delineated through the development review process, dedicated and determined to be protected that way.
I see Commissioner Will. Commissioner Will, please go ahead.
Thank you, Chair Lockwood. I guess it kind of goes back to my original question, maybe just a clarifying question. because some of my fellow commissioners brought up the question about maps, and you guys were clarifying maps about how they're general, and there will be a future process by an applicant for some use or some request for approval from the agencies to identify more clearly what's on their property. So the maps isn't really the main reason why this whole revision process happened. It's something in the language. It's a question I get. It was something in the language that didn't provide clear and objective standards. So mostly what we're talking about is looking at the code language or the approval criteria language. That's really where the crux of the issue is, as opposed to the map.
Well, it's kind of twofold. The board got to the point where they were wanting to see where the natural resources remain, so they could make regulations that would be applied to those special areas. And so it's a bit beyond what the Land Use Board of Appeals decided to do. But the board recognized that the inventory hadn't been updated since the 1980s, and we had kind of two running maps. We had the Metro map going that needed to be subject to the requirements, as well as our 1980s map. And so there was some confusion about that, and wanting to kind of recognize the development that has taken place over time.
Chair Lockett, if I may follow up. So in the process of our review in the coming weeks and months, we're going to be focusing on the code or the approval criteria or the processes to make sure that they are clear and objective, and the scientific determinations about where the boundaries are on the map are going to be outside of our purview. Like, how will we know whether the green line should be moved 10 feet to the left or not?
Sure. So we've been tracking that issue. We have a environmental consultant that's been reviewing the maps and making some determinations. But it's a computer kind of generated exercise, right? We haven't field tested all of these areas, so there's bound to be some inaccuracies. You might hear from people testifying that I don't have anything but a flower bed there in my backyard, and there's no habitat, so to speak. So you might hear some testimony like that, and we'll be following up to make sure that information is given to our environmental consultant, and that they can evaluate the information that someone asked to do that. We also will have in our code a map correction process. So for those situations where we might have overlooked a property or had information that's changed as well.
Yeah, so the review process that we'll participate in, we'll be watching and listening for like gross errors, but those fine, minute details will get cleared up, when a specific application is submitted with the applicant's own consultant creating a detailed map. Is that what the plan is?
Yes, that sounds right.
Okay, thank you for clarifying that. I just don't want to we learned about Robert Rules of Order today, and I don't want to get bogged down in trying to shift the lines on the map. If we don't have personal knowledge of it, it's probably close enough, and in most cases, unless somebody identifies like something that's obviously way off. Thank you.
Well, I would point out, I just thought it was important what Ms. Miller said, that the map, there'll be a process in the code for addressing any kind of discrepancies or inaccuracies in the map. Yeah. Any other comments or questions from commissioners? Okay, not seeing any. I think we're done. Thank you.
Great.
Are there any planning commission announcements this evening? Any? Are there any objections to adjourning? Commissioner Will.
Chair Lockwood, thank you. I just have one question about these important meetings. I know in the past, we've asked the question about in a meeting where there might be a lot of public attendance, if commissioners who can attend in person should try to help facilitate that. Is this something that's going to be coming up in these important meetings where staff encourage us to show up in person, if possible?
So the first hearing will be July 24th, and that one we would expect that there would be public input. The next two meetings, June 5th, I think, was being canceled. So June 26th and July 10th. At this point, our work sessions like this.
For this ordinance.
For this
We do have
ordinance.
a hearing on June 26th.
Correct.
So
Depending on what
the
happens.
question is about when they should plan to be here.
Right.
I'd say that we'd encourage you to be here when there's a hearing. And so that's generally going to be, we're trying to put those in evenings because we think that's easiest for planning commissioners. That's what we've heard. So we're trying to hold the hearings at our evening meetings. That's not always going to be possible. So there will be some daytime hearings as well. So we'll do the best we can. Staff are always here. And so if a planning commissioner would like to be here in person, that's always an option available to you. But we do generally think that when there's going to be a lot of public testimony, it's going to be easiest to run the meetings in person.
Anything else, commissioners?
Thank you.
Any objection to adjourning? Without objection, we are adjourned. Good night, everybody.
Thank you.